Welcome to EUPrivacyForAll, Session 11 on GDPR, Data Processing Principles, Article 5. A caveat as usual. What was already posted online and what is to come. Data processing principles in Article 5 were set forth by European Parliament on the basis of what already existed in the Directive: lawfulness, fairness and transparency, purpose limitation, data minimization and accuracy. Those principles were worded as such in Article 5, and others were proposed, but not retained. For instance, effectiveness, that is to say, processing in a way that effectively allows the data subject to exercise his or her rights. Being entailed by other provisions in the draft, it was not set forth. Integrity was also another principle that was mentioned by European Parliament. On EU Council side, it was security principle. In the end, the final wording recognized both. On EU Council side, the input targeted a further processing for achieving purposes in the public interest or scientific, statistical or historical purposes that shall not be on the principle recognized as incompatible with the initial purposes. But most of all, one added value from EU Council draft is the fact that the controller shall be responsible for compliance with all those principles. This is the accountability principle. The key provision in GDPR regarding principles relating to personal data processing is Article 5. As already stressed, all the principles laid down in the Directive are also laid down here: lawfulness, fairness and transparency, purpose limitation, data minimization, and accuracy. Additional principles were worded in a different and more specific way, that is to say, storage limitation, integrity and confidentiality, and most of all, the crucial principle laid down in GDPR, that is to say, accountability. Among all those principles, the one of lawfulness remains a core one. Any processing of personal data should be lawful and fair. That is to say, basically, it shall be transparent. The principle of transparency requires that any information and communication relating to the processing of those data should be easily accessible and easy to understand, and that clear and plain language is used. It also means that individuals should be made aware on risks, rules, safeguards, and rights in relation to the processing of personal data, and how to exercise his or her rights in relation to the processing. It finally entails that personal data should only be processed if the purpose of the processing could not reasonably be fulfilled by other means. Other provisions on lawfulness in GDPR might be interesting. The one on the fact that having a contract to be signed or a contract being implemented shall mean that the processing of data is lawful. The fact that a data subject's life or the one of another person might also justify lawfulness of processing. Finally, to check on lawfulness of processing, the right of access should be ensured. Recital 31 basically recalls that a processing to be lawful should be considered on the basis of an initial consent of the person concerned or of any other legitimate basis. Currently, the Directive lays down in several recitals and articles the same principles as in GDPR, but storage limitation is not that specified and accountability is not mentioned as such. Even in GDPR, accountability is mentioned only twice, once in Article 5, and the second time is in Recital 67 on breaches and security. What should accountable data controllers get prepared for? Basically, keep on implementing the Directive core principles of lawfulness and fairness. Also, not further processing data in a way incompatible with the initial purposes for which the data were initially collected. Tightly frame further processing for archiving purposes in the public interest or scientific and historical research purposes or statistical purposes. Keep on only processing data that are adequate, relevant, and limited to what is necessary. This is a little bit new. Take every reasonable step to erase or rectify inadequate data. Of course, this obligation existed in the directive, but now it becomes a key obligation for data controllers. As much as de-identification, whenever direct identification is not needed anymore. Keep on using appropriate technical or organizational measures to ensure security. And finally, be ready to demonstrate compliance, that is to say, to meet the principle of accountability. Finally, the key question is to know how accountability will be assessed. Will it be mainly based on technical and organizational measures taken, on the documentation provided in case of audit or inquiry, or on the processes put in place?